So in the yesterday's session, we started with the concept of objects clause of memorandum. So we went into section number. Everyone, please stop. We went into section number 13, which will be talking about the concept of alteration of memorandum. In that, we came to subsection number 8 and 9, which will be talking about the concept of change in the objects clause of a memorandum. So memorandum objects clause change, if you want to make, the procedure that one has to follow, that has been provided in section number 13, subsection number 8 and subsection number 9. So we discussed that very much in detail in the yesterday's session. Overall idea I said in the objects clause. Now we are going to deal with understanding the provision as a whole and seeing the chart in this regard. Once that is completed, we go to the other clauses of memorandum, like liability clause, capital clause, association clause. Okay. So even before we go into that, please now see the screen in this regard. This is the one we are putting out. Section number 13, subsection number 8. Let's come to the Bail Act, everyone. Please read. A company One second. I will read. Sir, okay. The provision that has been specified in 13.8 is as follows. A company which has raised money from the public through issue of prospectus and still has any unutilized amount of money so raised shall not change its objects for which it raised the money through prospectus unless a special resolution is passed by the company, and the details as may be prescribed in respect of such resolution shall also be published in the newspapers, one in English and another in the local vernacular language, which is in circulation at the place where the RO of the company is situated, and shall also be placed on the website of the company, if any, indicating therein the justification for such change. The dissenting shareholders shall be given an opportunity to exit by the promoters and the shareholders having control in accordance with the regulations to be specified by the Securities and Exchange Board. This is what they have given in 13.8. Please read the point clearly before we start. What happened? Oh, no. So please read the point. Section number 13, subsection number 8. Please read the content for a while. We go with the analysis again. Okay. So completed everyone reading? Listen first. Question is as follows. Point number 1. This section is talking about a change in which clause of memorandum? Everyone? Objects clause. Shall not change its objects. Shall not change its objects. Okay. Now listen carefully to the point. Please listen. Tell me. Point number 1. Objects clause of a memorandum. Whenever you want to alter the objects clause of a memorandum, it requires which resolution to be passed? Everyone? That's all. Because any an alteration of memorandum as per subsection number 1, I told you very clearly, yesterday also I said this point. Any alteration will attract subsection number 1, subsection number 10. So, read subsection number 1 of section number 13. Same as provided in section 61, a company may, by a special resolution, and after complying with the procedure specified in this section, alter the provisions of its memorandum. So, first point, any alteration of an objects clause require what resolution to be passed? That is one point. Next, come to subsection number 8. A company which has raised money from public through prospectus and still has any unutilized amount of money so raised shall not change its objects for which it is raised the money through the prospectus unless a special resolution is passed by a company. And he is continuing about the point. So see here now. If you observe yesterday's session with regard to the registered office clause alteration, whenever I want to change registered office from one state to another state, first thing, it is a change in the city. Therefore, first a special resolution is required to take the permission of shareholders to change from the local limits of the city. Second special resolution is required not for taking permission of changing. It is for the alteration of memorandum after such change. So, these are the two things. Listening, So, how many special resolutions are required? 2 special resolutions are required. Same thing happens also here. Any way to alter the objects clause of memorandum, which resolution is required? Where it was said? Everyone in the class, where it was said? Section number 13, subsection number 1. It was clearly said that any memorandum alteration required what resolution? Objects clause also same thing is required. That is alteration of memorandum. This is not alteration of memorandum. 1380 is not talking about alteration of memorandum. Anyway, any alteration requires special resolution. No doubt in that. However, this is a special case of alteration. This is a second special resolution required. Along with normal special resolution you generally pass, this also required to be passed. Clear everyone? Listen, what is our company? Our company is a listed public company. That's implied. Sir, how can you tell that this is a listed public company? Clearly he said that I am raising money from whom? Answer. Moreover, SEBI guidelines are applicable to me. SEBI guidelines are applicable to whom? Listed companies, not for unlisted private companies. Therefore, it is implied in this section that the discussion we are going to make is about a listed public company, not about a normal private companies. First point number 1. So tell me, 13.8 is a section which is talking about what? Public company, private company, listed public company. It has raised money from the now listen carefully. Please listen. Shall we continue? Point is, I raised money. From whom? Public. I raised, everyone read the section properly, yeah? You will always tell yes, like, so, it raised money from public. Say for example, 100 crores. It raised money. That 100 crore money has been utilized. Okay? That 100 crore amount has been utilized. That utilized amount given profits. That 100 crore amount also given some profit. That means that profit is also a amount that is derived out of this particular 100 crore or not. That was kept in the form of a reserves and surplus unutilized. Repetition. I raised how much amount? From that, how much profit generated? Say for example, a 5 crore profit has been generated out of that. That 5 crore, 4 crore I transfer to what? Reserves and surplus. Reserves and surplus means utilized, unutilized. Answer. Now tell me, can I change my objects? Answer. Happily, yes, sir. Here the word used is amount out of money so raised. Only that amount you need to take into consideration. Whether 100 crores capital has been utilized or not, you need to check. Profits derived out of it, income derived out of it, it is no way concerned about. That's why I use the word still has any unutilized amount of money he didn't use. Unutilized amount out of the money so raised. The main golden word is out. Read again. I told you, you will always tell yes. Read again. Start reading. A company which has raised money from public through prospectus. First, a clear indication that was given. Public through prospectus. When I use the word, I am talking about which company? That is public company. Which kind of public company? Next. And still has any unutilized amount of money, unutilized amount out of the money so raised. Continue. Shall not change its objects for which it raised the money through prospectus unless a special resolution is passed by company. And first one is talking about disclosures. Second one is talking about exit offer. These are easy. Okay? And now, first point number 1. Which kind of company I am? Private or public? Normal or listed? How do you know? Prospectus can't be issued by private companies. Point number 1. Those who want to get listed, they only will issue the prospectus. Which chapter it will come? Prospectus chapter this will come. Section number 28. First section we will read this. Okay. So any company which want to raise money from the public will issue prospectus. To whom? And raise. That money raised out of that particular amount was utilized or still unutilized? During the meanwhile, company want to change its. Can it change or cannot change? It can change with a special resolution. Special resolution means it requires 100% approval, 75% approval. Answer. Sorry, I will give an example. 1,000 members attended. How many should vote in favor? 780 voted in favor. Resolution passed or not passed? 780 passed. Balance how many are there? 220. Those are called as dissenting. Understood the point or not, everyone? They are assenting, they are dissenting, dissenting. Those 220 dissenting will be given a exit offer. When I call exit offer, they will be given exit offer not as per the market price. I told you yesterday one point. They will not be given as per the market price. They will tinker with the market prices. Therefore, SEBI will come. They will value the share prices. They will decide an amount. You pay that, they will leave the company. Clear or not, everyone in the class? This is the basic idea behind this particular point. Clear? Next, number 2. Whenever the companies are changing the objects, I repeat, whenever companies are changing the objects, it is a very important issue that is going on in a company. Therefore, let every shareholder of a company, of a listed company, let them know what is happening in this company. Therefore, necessary disclosures are required. Disclose in the newspaper. One newspaper, two newspapers. One will be in English, another will be in with the local vernacular language. Here local vernacular language is Tamil. Like that, according to the place, what is the local spoken language in that newspaper. Here one popular newspaper will be there, na? In that newspaper you will give. Clear? In English newspaper normally, generally the Hindu you will give. And in Tamil newspapers, whatever is the local popular newspaper is there, in that newspaper you will give the particular advertisement. Clear everyone in the class? This is one point. Next. Why you are changing the objects? I should know about it or not? That's called as a justification for such a change. Why? Why you are changing the objects? What is the purpose? So you need to clearly inform them why you are changing the objects. Why you are changing from one object to another object. Everyone understood the concept clearly? Next. Sir, last point, needless to discuss once again. Yesterday I told you very clearly, those 220 in our example are called as dash. They are accepting or not accepting. Happy or unhappy. Let them, we should make them happy by giving cash. Okay, cash for what? Cash for what? Shares. We will take there and we will pay them. Cash will be paid as per what price? Market price. Yes or no? Yes sir. Yesterday why I told that example here. All of a sudden one screenplay story created just to explain you that market prices are always manipulated. Every chance is there that the market price can be manipulated. So therefore to show that example I said that. Sir, anyway, everyone understood the logic clearly, yeah? That's all. This is what? Subsection number 8. Next. The registrar shall register any alteration of memorandum of the company and certify the registration within a period of how many days? 30 days. From what date? From the date of filing special resolution. Sir, we have to file with ROC. We have to, one second sir, I will come. The registrar shall register any alteration of memorandum with respect to the objects of the company and certify the registration within a period of 30 days from the date of filing special resolution in accordance with clause A of subsection 6 of this section. Simply, any alteration in memorandum with respect to what clause? Objects clause. He shall certify within a period of how many days? 30 days from the date of filing the special resolution. Okay, you have to file. He has to certify that filing within a period of how many days? 30 days. 30 days from what date? From the date of filing the special resolution. Sir, I have one or two questions in this. First answer. Point number 1. I am going to change which clause of memorandum in this case? What are the clauses we completed already? Name, situation, objects over. So name, situation completed. Next objects also over. But still answer. I want to change my objects clause of memorandum. Tell me what resolution is required? Complete procedure you explain me. First one. Board of directors has to first initiate a change. Next, shareholders bypassing a special resolution. Next, that's all. Normally, if you want to change, a private company is there, unlisted public company is there, they want to change their objects. In such case, only 2 steps, BOD, alteration of MOA, over. But in case of listed company which has satisfied those conditions like unutilized amount, etc., for them only all these conditions are required. Which conditions? Which conditions are required for them? So amount unutilized, all these things are applicable for whom? If it is a listed public company raising money from prospectors and amount unutilized and changing the objects, 5 conditions has to be satisfied. Number 1, listed public company raised money by the issue of prospectus, amount is unutilized and it want to change the objects, that's all. And it want to change the objects. Say for example, I will give you one classic example to understand. Sir, everyone read the section properly? I will ask once you read. 1 minute time. Read it first. Let us see how great you will read. Sir, some person has a doubt, na? You can ask. You can. That's why the word used is opportunity. It's not obligation. Exit offer. You may accept, you may not accept. Over. Next. Ah. Through amount through? Anything. It can be anything. I didn't understand the question. Rights issue, why it came suddenly? Rights issue is not issued to public, first point. Rights issue is issued to existing members of the company. That provisionally does not get attracted. Rights issue, this will not get attracted. This will get attracted only if you issue. Rights issue don't require prospectus, first point. This will not get attracted. This will get attracted only for public issues. Yes. Not buyback, reduction of capital. Another mode is there. Company? That question will not arise. Listed companies can't afford to put advertisement means you can't give that excuse. You have to if you want to change objects. Unutilized amount is there now, use that. One second. I didn't understand the question. SEBI regulations? No, not in that sense. He is telling that the descending shareholders shall be given an opportunity to exit by the promoters and the shareholders having control in accordance with the regulations to be specified by the SEBI means regulations which are specified. When this act was written, that guideline is not there. After this act, those guidelines were redrafted. Therefore, they are giving that reference. You go there, when it is drafted, there they will explain what are the procedures. Valuation procedures they will tell there. Yes. If special resolution is not accepted by the shareholders, no, you can't get it back. You can't change objects, that's all. Same business will be continued. You can't change objects, that's all. There is no provision that you have to refund the money. Capital refund concept is not there anywhere. It is at the discretion of board of directors. No, not required. You can happily change it. Completed, everyone? Hello? Completed, Shall I ask the question now? Okay. Sir, I will ask a question. Answer. Please, everyone, be in this world. Let's start the point clearly. So the company has raised money from public through the prospectus and still has any amount unutilized out of the money so raised, shall not change the objects from which it is raised through the issue of prospectus unless special resolution is passed by the company. Okay. See here. I will write conditions. Sir, objects are of two types. One, main object, ancillary incidental. Anything is an object. Anything is object. Sir, company has a borrowing power. Company has a power to borrow money. Borrowing money, or a company has a power to issue debentures. Company has a power to issue preference shares. Clear? Like that, so many objects will be there. Main objects will be there. Incidental, ancillary, or other objects. I told you there are other objects are there. So it may be called as an ancillary, or it may be called as an incidental, or it may also be called as a other objects. Anything is an object. If you want to touch and change, it becomes alteration of objects. Clear, everyone? Yes, now tell me. Point number 1. There is a listed company. Point number 2. It raised money through public. Point number 3. Amount is still unutilized. Point number 4. It has issued a prospectus. And now it want to change. Delta means change. Now it want to change its objects clause. Say for example, other objects in the objects clause of memorandum. Clear, everyone? First point. Now first everyone tell me, section number 13 subsection 8 will get attracted or not? First point, everyone. Yes, will not. Only the object for which the prospectus they mentioned, if that changes, then only section will get attracted. Read section 13.8 once again. A company which has raised money. Everyone read. Read everyone. Read, amma. Read. A company which has raised money from the public through the prospectus and still has any unutilized amount out of the money so raised shall not change its objects for which it is raised. Only that object if you change for which it is raised. Simply to know, main object change only will be considered here. When you are raising money, you will tell for what purpose you are going to utilize or not. That object change only will get attracted. Other ancillary objects if you change, that doesn't care. This section will not get attracted. You didn't read. Read again now. I asked you very clearly, read properly. I know about you, Gada. And moreover, these questions, these type of questions didn't come in exam. If I were given a chance to prepare question paper one time, then full knockout that attempt. So each and every point, nook and corner we can touch. Today I asked for coffee, not water bottle. Like a hero you are walking by bringing water bottle. I asked for coffee, not water bottle. I said him 15-20 minutes back. Continue. Read. Section 13.8. Section 13.8. Now tell me, section 13.8 will get attracted. Please, no noise. Section 13.8 will get attracted when? If they change the objects, any objects, if they change the objects for which money is raised. I said education, I am changing to another. Then only this will get attracted. Are you understanding or not? So therefore, other clauses of memorandum or other changes in memorandum or other objects changes will not attract this section. I mean subsection number 8 and 9. Hope you understood the concept, everyone in the class. Answer. Yes, sir. Everyone. Yes, sir. Now answer my question. There is a listed public company. There is a listed. So section 13.8 not listening, everyone. Section 13.8 not applicable. Section 13.8 not applicable. Means special resolution required or not required. In this case, in my example, other objects change. Required or not required? That's all. So I will redraft the same example. Please answer clearly. First point, what is my company? It has raised from whom? By issue of money has been it want to change the main objects, other objects, then only section will get attracted. I don't want to change the main object. I want to change only the other objects of this memorandum. So special resolution required or not required? Required as per 13.1. Read again. Read again. So, two special resolutions are not required, but one special resolution is always required for any change in the objects. Happy everyone in the class? Very happy? Are everyone happy? Very happy? I try to keep you happy every time by giving wrong answers from your side. Okay, I ensure that you don't give correct answers. Sir, okay, everyone understood the concept. Can we go to the next one? Now answer. Summarize everything in the chart format. So what is the clause of memorandum we are trying to discuss now? First, see here. In a most comprehensive way, this chart has been prepared covering out all scenarios that are possible. Start. First one, alteration of objects, clause 13.8, 13.9. First, general case. General case. General case means what? Can you please explain what is a general case? Not other objects, unlisted companies, private companies, unlisted also, not in case of the main objects change, like that you can understand. Clear? See there. General case. Approval one, board of directors at a board meeting. Listening everyone? Approval number two, shareholders by passing a special resolution in a general meeting. That is for what? Alteration of MOA. Next, compliances. Tell me, what are the compliances required? Company shall file with ROC copy of special resolution and copy of a altered MOA. Within how many days? 30 days. ROC shall register the change and give a certificate again in 30 days. Up to here, clarity? Yes, very good. Next one, alteration of objects clause in a special case. Number one, applicable to whom? When applicable, accepted money from public by the issue of prospectus, amount is still unutilized. In such cases, approval one, same as in general case. General case of whatever is required, everything is required. And approval number two, same as in general case. Next, compliances. Advertisement in how many newspapers? One in, another one in the, and what offer should be given? Other complaints are also same. File with ROC, everything is common. Clear everyone in the class? So you see this chart first. Once you complete, then we will be going into the next part. But very important thing, these type of points you should make a note, very important. Okay, objects clause of memorandum requires CG approval. Objects clause change requires CG approval. Do not require any central government approvals. Clear? Yes. First point, everyone tell me, have you understood the section properly? So, with this, we have completed objects clause of memorandum as well. Sir, hope everyone had a clarity on all the concepts completed till now. What are the clauses completed? Name, situation, objects. We didn't just completed the clause. All the concepts surrounding them also have been completed. Please come to Bear Act on section 13 once. 13. Okay, ma? Now see here, section number 13 is talking about alteration of name, objects, register officer, any clause of memorandum. As I said, we didn't read 13 in one set. Whenever name comes, name concept completed. Register officer, register office completed. Objects law, objects completed. By the end of this discussion, had we completed subsection 1, everyone? Yes, sir. Subsection 2? Yes, sir. Come to subsection number 3. Completed, huh? Yes, Fourth, state to state. Central government creditors sufficient provision. Yes, 64 section. We completed. No, we have to do now. Next, 7, alteration of objects clause of memorandum. Sorry, whenever there is a state to state change, both the ROCs should communicate with each other. That concept, yesterday we completed or not? 8, 9, now we completed or not? 10th one, all alterations requires compliance of subsection 1, subsection 10. Already completed. Clear everyone in the class? Now we have to complete the 11th one. 6, 11. Once we complete 6 and 11, entire section number 13 containing totally 11 subsections. Slowly we have completed every line, every point. Okay, that's what I want to tell. We will not complete all the sections like a set. Wherever that point comes from, we will come to the bare act and we will complete. That's I promise. What I said is, every subsection, every proviso, every clause we will read, but not continuously. Section 13 means we can't read continuously section 13. Now what we have done is, objects clause means all concepts surrounding the objects clause we completed. Same with situation, same also with the name clause of a memorandum. The big clauses have been completed with this. We will be starting with other small clauses of a memorandum. Those will be talking about the concept regarding the objects clause also completed. See here. What are the other clauses of memorandum? Can you please tell? Liability clause, capital clause, association clause. These are the 3 clauses of memorandum. These are all discussed in subsection number 1 of section number 4. Please come to the bare act, subsection number 4. See there? I just also want you to confirm back this concept. Tick the concepts that are completed. Had we completed A? Yes, proviso to A. Yes, read and confirm. Yes, B. Yes, C. Yes, D. No, E. No, F. No, had we completed subsection number 2 of section number 4? 3. Yes, what is number 2? Name not to be offensive, name not to be undesirable. 3 will be talking about government patronage. 3B will be talking about whenever you are using the name of board, commission, national, state, central, or you are using such other words like bank, insurance, venture capital, mutual funds, etc., nidhi, those concepts are discussed there, attached to the rules we read. Completed. Next, 4th one, reservation of name. Had we completed? Yes, 5, 20 days validity of reservation. Had we completed? Yes, next, existing company change, instead of 20 days time, 60 days time will be given. Had we completed? Yes, answer? Yes, next, subsection number 6, 7, had we completed? No, we have to. Clear everyone in the class? Those we need to complete. In between, if you observe, this particular part we didn't complete. Why means no, it's not a penalty. Only one point la penalty is there. Remaining we have to read. Section 7 we will read this. Which section? Section number 7. Thank you, bro. So section number 7 la we will read this. Which one? Section number 4, subsection number 5. Subsection number 5. Okay, na? Subsection number 5. Item number 1 over, what is the next one? 2. This 2 we will discuss in section number 7. Why? Reason also I will tell that. Why? Clear? Reason for that also I will tell. Why we will be reading there, not here. Clear everyone in the class? Sorry. So 6, 7 we have to read now. Sir, what is 6, what is 7? That I will explain once you complete section number 4 above content. 4 1 A B C over, 4 2 over, 4 3 over, 4 5 also over. Just 2 3 points are left out to complete section number 4 as well. Please, for my cake, everyone read point number D, liability clause. The memorandum of a company shall state the liability of the members of the company, whether limited or unlimited, and also state, in case of company limited by shares, that the liability of its members is limited to the amount unpaid, if any, on the shares held by them, and in case of company limited by guarantee, the amount up to which each member undertakes to contribute to the assets of the company in the event of its being wound up while he is a member, or within 1 year after he ceases to be a member, for the payment of debts and liabilities of the company, or such debts and liabilities as may have been contracted before he ceases to be a member, as the case may be, and to the cost, charges and expenses of winding up, and for the adjustment of rights of the contributories among themselves. Read this. D point. I will give you 2 to 3 minutes time. Please don't sit idle, don't sleep, don't sit idle in class. Read properly. Take 2 3 minutes time, no problem, but read it. If you don't have, at least I am making it full screen. If you want, you can read also from the screen, but please read, don't waste your time. Completed, everyone? Hello. Shall we continue? Listen now. Which clause of memorandum is covered in section 41D? Listen first. Let me first explain you the concept of how the liability clause actually works. Mechanism of liability clause, once you understand, remaining concept is very easy to understand. See here. Whenever we say liability, liability can be of two types. One is a limited liability and second one is unlimited liability. Limited liability or unlimited liability, first one, which clause of memorandum we are dealing? Liability clause of memorandum. Means it will specify the liability of the members, whether it is limited or unlimited, it will clearly specify in the memorandum. That's the purpose of a liability clause in a memorandum. Point number one over. Point number two, very important. Not only that, he used the word and also state, not just saying limited or unlimited, you should also state that if the company we are talking about is a limited liability company, you should tell which kind of limited liability it is. Limited by share capital or limited by a guarantee. If it is limited by share capital, further you have to specify that your liability will be limited to the extent of unpaid amount on shares held. Clear everyone? Guarantee company, it should tell that your liability is limited to the amount of guarantee undertaken. Undertaken means promised. Promised in a written form is called as what? Undertaking. Sir, let's start once again. Tell me which clause of memorandum we are discussing now? Liability clause. Listen. Liability clause will specify what is the liability of members in this company, whether limited or unlimited. If it is limited, again two branches will come, whether it is limited by shares or whether it is limited by guarantee. Some company don't have shares. Some company don't have shares. They will only have a guarantee company. Now question will arise from your side. Without share capital, how a company can be? That's a question, yes or no? Listen carefully. Generally, companies start with a share capital, but certain section 8 companies will not have a share capital. They don't encourage the concept of share capital. Okay? They will have only corpus. They will have only corpus. Sir, I will explain maybe this way. Sir, we started a particular religious place like a temple, a church, a masjid or gurudwara, whatever the religious places are there. A person started it. A temple or a church or a masjid, as the case may be. Listening everyone? Now, temples will be run in India because of share capital, because of donations. Temple or masjid, church, whatever the case may be. Because I know only that particular area, I am talking about it. With due respect to every other thing as well. My point is, when you go to a temple, if you observe, the entire expenses of the temple will be incurred out of issue of shares. Donations. That means, listen, please, there are two types of companies. Companies which will work on the basis of the share capital. That means the daily running of a company will be only because of the share capital that you have invested. Listening everyone? Second type of companies are also there, which will work not on the basis of your bloody share capital. You need not give. Public will give donations or subscriptions. With that only we will run it. Those kind of entities which don't require share capital. Clear? Those kind of companies are called as a guarantee companies. Those are called as everyone. Those are called as a guarantee companies. Like share capital will not be there because money is not raised by way of share capital. Money is raised in the form of donations and subscriptions. Clear or not everyone? I don't want any person to control my company. In that case, don't go for share capital. If share capital is there, directly or indirectly, a person will control your company. Yes or no? Therefore, there is a temple, church, or a masjid, or a gurudwara, whatever the case may be. I don't want any one individual influencing the temple or a masjid or whatever the case may be. In that case, don't go for a company having a share capital. If you start issuing the shares, one person will buy more, one person will buy less, one person will control, one person don't have a control. Therefore, whenever a entity is not dependent on the shares, but will be running because of the donations, they will incorporate the company as a company limited by guarantees. Classic example is Rotary Club. Rotary Club is a company limited by guarantee. Have you heard about Rotary Club? Everyone in the class? Rotary Club is there? Rotary Club is a company limited by guarantee. Sir, what does it mean? Rotary Club, I am a member of a Rotary Club, Midtown Club, Hyderabad. Like that you can also become. Nothing, no qualification required. Membership fee you need to pay every year. Listen please. If you pay a membership fee of 30,000 per annum, they will be giving you a membership. Reasons, everything I will tell you later. First listen. Why I am paying means I am not a damn bloody fool. So generally pay 30,000 to them. We should get some advantage out of it. I will tell you at the end of the story. First listen carefully. Rotary Club started in India. Outside India it has originated. In India also they started their Rotary Club operations. India they started as a Rotary Club in India as a Section 8 company. Section? They started. Rotary Club is running not because of the shares. It is running because of what? Like me, there are lakhs of members who are paying what fees? Membership fees, subscriptions, all these things are paid every year. From that amount they are going to utilize everything. So can Kaushik Mukesh influence Rotary Club by buying more shares? Shares are not there. Then how can you influence them? Clear or not everyone? So therefore listen carefully. Whenever a company is limited by a guarantee, you will not buy the shares of that company. You will only just, if you want, you will donate some amount to that particular company. From donations, they will run their entire operations. Rotary Club is running today means it is not because of the shares. They never went for share issue. They are running because of the donations, subscriptions, membership fees, legacy fees, etc. Hope you are clear, huh? Now listen. Now can Kaushik Mukesh influence Rotary Club? Because I am not a... Can you purchase the shares of Rotary Club? Because shares are not there. It is running on the basis of donations, subscriptions, membership fee. Clear everyone in the class? Not because of the share capital. Have this clarity first. Clearer? Now, how it will work? The promoters of Rotary Club will be there, na? Outside India, no, in India, no, some people will be there or not. These people, at the time of incorporation, they will give a guarantee to the guarantee company like Rotary Club. What they will tell? In future, if Rotary Club is wound up, say for example, in future if it is wound up, at the time of winding up, I have to pay all the liabilities by selling the assets or not. If assets are sufficient to pay the liabilities, fantastic, no problem. If the assets are not sufficient to pay the liabilities of Rotary Club, then we will pay the amount of guarantee what we are promising. Clear everyone? I am a promoter one of Rotary Club. I said, at the time of winding up of Rotary Club, I will pay 2.5 crore. That's all. I signed at the beginning of the company. Clear everyone in the class? I will sign. I will sign on shares. I will sign on guarantee document. That will be having an effect today na, at the time of winding up. At the time of winding up, I will pay unpaid amount on shares. I will pay the guarantee undertaken. Every member has to do now. Only promoters will do na. Promoters. Kaushik Mukesh, why I will do? Why I will do here? Why I will do? 1 year I will pay membership fee. I will explain you. 2020-21 I didn't pay membership fee for Rotary Club. Why I will be... COVID is ruling the world. I am sitting at home. What I will do at Rotary Club? I have to join Zoom sessions. Zoom I hate. So I have to sit in Zoom. I will be seeing the people. You continue. I will see you. What I will do, I didn't pay membership fee. Again this year I paid 2022, I paid the membership fee for the calendar year 2022. So now what you have to understand, calendar year 22 I paid, 2021 I didn't pay. They called me around so many times to pay the membership fee. I said, Namaste, I can't pay. 30,000 I can't waste. When some advantage is not coming to me, why I have to pay 30,000? 1,000, 2,000 means okay, we can pay. 30,000 including GST. Why I will pay? So therefore I said that I am not interested this year. So I didn't participate. 2022 again we are going now. Now I am not a person who is giving guarantee. If you really ask me to give guarantee, I will put Namaste, I will go out. Why I will give guarantee? Promoters of that company will give a guarantee. If assets are insufficient to pay the liability, promoters, whoever give the guarantee at the beginning of the company, they will give the guarantee amount. For example, winding up happened here. Assets are 100 crore. Liability is 150 crore. Tell me how much deficit is there? You are not listening. Everyone, deficit. I am a promoter giving 3 crore guarantee. Now tell me how much I will pay? Come out, that's all. Your liability over. Your liability is unlimited or limited? Limited. But limited not to unpaid shares, limited to the guarantee. Okay, clear everyone? Please read that answer. More conceptual clarity also I will give once you complete the remaining part. Please read it once. I will put the screen before you. Please read it. I am talking about liability clause. Completed? Now tell me, liability clause of memorandum law, what I will mention, liability of the members, whether limited or unlimited, and shall also state, in case of company limited by shares, you should tell them very clearly that liability of its members is limited to the amount unpaid, if any, on the shares held by them. Okay, next. And in case of a company limited by guarantee, the amount up to which each member undertakes to contribute to the assets of the company in the event of being wound up. Okay, now listen. Sir, I will give a guarantee. Okay, done. I will give guarantee for what? Sir, assets, please, listen. assets are there, say 100 crore, liability is 150 crore, say as an example, okay, assets 100, liabilities 150. Now listen properly to the point. 100 is sufficient to pay 150 or not sufficient? So collect a guarantee amount now. Started collecting the guarantee. Now in this liability, I mean in this debts, am I liable to all the debts that were contracted by the company? Yes and yes. Listen carefully what has happened. Please see here. This is company started. Where company started. Somewhere at the 7th year, I joined the company as a member. I continued for 20 years, means up to 27th year. Clear? And I came out of the company, means I sold the shares and I withdrawn from the company and I came out, okay? And I came out and I was discharged as a member, simply to tell I have become a non-member in the 27th year. Means I continued for how many years here? 20 years I continued as a member. I came out. Okay? Now, my question is very clear. I am liable, my guarantee amount what they collect will be used to pay liability before my coming into company, or after my coming into company, or after I leave the company, is a question now. I repeat once again. That's why always I ask you, read properly. At that time you are mechanically reading. See the screen. Tell me. See the screen. What is this date? What is the event happening? I became a member. Okay, I became member immediately after 7 years. By shares or by guarantee? Guarantee. Okay. Now, debts are there between 0 to 7th year. Debts are there when I am a member. Means 7 to 27. Clear? Debts are there even after I came out. Some debts are there. Those are all the debts. Okay, what? After some number of years, company went into winding up. Now, am I liable for the debts before my coming into company or after my coming into company? Even after going out? I say question. That means I give 2.5 crores kada. For what purpose you will utilize this 2.5 crore or 3 crore, whatever I give? I will be liable for before, after, or during, or after any period. What is the provision that was provided there? First point number 1, your guarantee amount will be used to pay two things. Number 1, contribution towards the assets. Contribution towards? Sir, I didn't understand. What do you mean by contribution towards assets? See the concept. Asset value is how much? Please see. Liability. Deficit is there on liability or assets? Deficit is there on liability or asset? That means I need to contribute towards asset or liability? That's called as a contribution towards asset. Clear or not, everyone? So you should contribute towards the assets of this particular company. How much deficit is there? Answer. Now I give a guarantee for how many crores? 3 crores. 3 crores you take. So I gave a guarantee of how many crores? 3 crores. Do I require to give all the 3 crores or not? Is a query now. Clear? I will give my amount of whatever I promised as a maximum 3 crore amount, subjected to 3 things. Number 1, I will be liable to pay the debts of the company before I became a member. What is that? Before I became a member. The day on which you became a member, when you became a member? On this day, whatever the debts are there, for that I will become liable. After I became a member, 20 years some debts are made or not? In the 20 years, some debts are taken, some debts are paid. I am talking about those which are outstanding after 20 years. Okay. So those things, during this time, I will be liable. I came out. Even after coming out of the company for another 1 year, whatever the debts are there, for all these amounts, your guarantee amount will be used as a set off. So tell me, you will be liable to pay 3 kinds of debts subjected to 3 crores amount. Everyone, what are all the debts? Debts before, after, or during? What is the provision? Tell me. First tell me, am I liable to pay the debts before my coming into company? Before, because once you come now, you are accepting all the past liabilities. Liable. Second one, during my membership, any debts are there, am I liable or not? I became a non-member. After that also I am liable or not? No. After that you are liable only for debts created after 1 year. For that period you will become liable. So tell me, what are the 3 periods they are covering in the section? Number 1, before, during, 1 year, after. Everyone repeat. Number 1, number 1, number 2, number 3. Everyone once again repeat. Number 1, number 2, number 3, 1 year after. After what? 1 year after what? 1 year after he became a member, ceases as a member. Even for 1 year, you still become liable for all the debts created. Clear or not, everyone in the class? This is what you want to tell. Not only the contribution to assets, you are also liable to contribute to the costs and expenses of the winding up. Costs and expenses of the winding up. Everyone understood the point or not, everyone? Everyone? Now listen carefully to the point. I will go a level beyond this and I will try to explain. Please see here. There are totally 20 members in this company. Please explain me, how many are there? 20 members are there in a company. Clear? Now listen carefully. 20 members are there. 20 members, there will be division among all of them. Okay, there will be a division. 20 members, 50 crore deficit is there. Divided among how many members? 20 members. Means each person has to share how many crores? 2.5 crore. Clear, everyone in the class? Now answer my question. This 2.5 crores will be collected from whom? Members who have undertaken the guarantee. Clear, everyone? Now tell me, take my case. How much I given a guarantee totally? But my portion came to how much? Therefore I am liable only up to 2.5 crore. Maximum is 3. If this is 50 members are there, how much each person? 1 crore only each person has to give. Listening, everyone? How much each person has to give? 1 crore. 1 crore each person has to give. 50 crore deficit. 50 members are there who have given guarantee. Means each person has to bring how much? 1 crore. But I promised how much? That does not mean by force you have to give extra 2. Maximum is 3 crore guarantee. So I will be giving how many crores guarantee now? 1 crore I will pay. Remaining 2 crores I need not pay any amount. Clear or not, everyone in the class? That is the idea behind. So please summarize and tell me what clause we are reading now. It mentions what? Liability. Of whom? Whether it is? If it is a limited liability, what will happen? There are 2 types. Limited by shares, limited by guarantee. If it is limited by shares, I will be liable to I will be liable only to the extent of amount unpaid on the shares. That's all, my liability over. But if it is a liability limited by guarantee, danger will come. The person who is giving a has to pay for 2 things. Number 1, assets, costs. Assets, costs. Now tell me, for the debts of the company, what debts I will be liable? Number 1, before my membership. Before my membership, yes or no? While membership, after membership for 1 year. All these 3 debts, whatever contracted, to that extent, my portion I will be liable. Clear or not, everyone in the class? That's the idea behind this particular point. This is all about the liability clause. Completed. That's all. Alteration will not be there for liability clause. What will not be there? Alteration will not be there for liability clause. So reason is very clear. Members will punch on your face when you start as a limited liability company and converting it into unlimited liability. Because they also wear leather slippers or shoes. Whom? Members. They will punch on our face if you convert liability. And moreover, do you know, when you start as a company limited by shares, how can you convert into guarantee? Are understanding or not? You can't do like that. That circus feat is not possible. Therefore, there is no concept called as change in the liability clause. Association clause, liability clause, you can change or cannot change. Cannot change. You don't have concept of liability clause change. Hope everyone is having a clarity. Everyone in the class? Yes, everyone in the class? Yes, shall I continue? Yes, sir, you can ask. ₹50 crore I understood. Next. Yes. You have given guarantee only of? You can, so many situations will come like that. For example, you have given only guarantee of 20 lakhs, say, let us say. Okay? So, in that 1 crore deficit, you can pay only how much? 20 crore. Your obligation is discharge. You will go. Lastly, some deficit will be there, na? Company will be declared as insolvent. That company, that guarantee company will be declared as insolvent because even after paying the guarantee amounts promised by the promoters, still company is having a deficit. Yes, they can collect. How, when deficit is not there, when you have given guarantee of 50 lakhs, when the amount for each person came to 1 crore, you will pay only 250. Same thing, if a person has given 1.5, he will bear the excess. Anyway, he has given guarantee. Kada? As simple as that. Even after paying the guarantee by all the members, still deficit is there, na? Company will be declared as an insolvent company. That means the guarantee also can't save this company. No, not after winding up 1 year. See here. Debts and liabilities before he ceases to be a member. One is after he ceases to be member. 3 words are used here. While he is a member, after he ceases to be a member, not after winding up. Winding up after company are not there. Any? After 1 year he is not liable. Asal after 1 year is a torture for him. They are doubting him just to avoid these future liabilities you went as a member. So therefore 1 year is covered. Beyond 1 year anything is there, he is not liable for that. Okay, everyone. First answer my question, everyone. Understood the liability clause up to here, everyone in the class? 2 types of liability will be there. Limited, unlimited. Limited again 2 types will be there. Limited by shares, limited by guarantee. Clear? Unlimited liability is a rare case situations that will come. When it will come also we will see. Previously, if you remember, I have written somewhere section 7. Section 7. That is unlimited liability. I will discuss when we come to section 7. Linking concept. That's a rare case of unlimited liability company. When it will come, how it will come, what will happen, everything we will discuss in section number 7. Sorry, shall we continue with the point? Now tell me what clause of memorandum we completed now. Liability clause of memorandum is completed. Next. So we completed number 1, name, situation, objects, liability. Next one is what clause? Capital clause. Please read E point. Sir, first point, one second. Sorry to interrupt you, but capital clause of memorandum is not so great. Already I said this point, but I will explain in a easy way possible. After that you read. Nothing great in capital clause. See here. Tell me what will be contained in the capital clause? What will be contained in the capital clause? I told you. First serial number, name of the person, PAN, number of shares promised to subscribe, amount per share, next total amount, next one signature. Okay, now tell me which clause this is a format. Everyone please be in this world. Which clause this format will be there? See here, I will write a name A, serial number 1, name is A, some PAN number, number of shares 5,000, amount per share 10. So how much is liability? 50,000, and A will sign here. Okay na? That means opposite to his name, number of shares subscribed, everything will be there. This is called as which clause? And that's all. Whatever I am writing in this box will be interpreted in a text format here. Everyone start reading. In case of company having a share capital, the amount of share capital with which company is to be registered, and the division, underline the word division. Division. Sir, can you please explain what is the division here? 5,000 shares of rupees 10 each, that's a division. Division thereof into shares of fixed amount 10 rupees, and the number of shares, in my example how many? 5,000, which subscribes to the memorandum agree to subscribe, which shall not be less than 1 share. That means every person, every subscriber to memorandum should subscribe for at least how many shares? 1 share. The number of shares each subscriber to memorandum intends to take, how much in my example? 5,000, indicated opposite his name. That's all. This is what contained in which clause? Capital clause of memorandum. No explanation required for this, nothing great. Just read for a minute, we'll go to the next one. Hello everyone, completed? So, what clause of memorandum we have completed now? Capital clause. Okay. Please sir everyone. Whenever I call about one person company, there is a clause called as a nomination clause. Which clause? Which clause? If you observe in Companies Act, association clause will not be separately given. It is enshrined and inbuilt and kept as an integral part of capital clause. Capital clause will contain both capital as well as association of persons being subscribers to the memorandum. Okay, so this covers both. One person company la association clause can't be there for one reason. Association means minimum how many persons must be there? Hey. Association means minimum how many persons are required? 2 are required. One person company, how many members will be there? 1 member. Then from where you will get association? Therefore clause A not there. Everyone understood? So instead of association clause, some clause should come and sit in place. Therefore nomination clause has come. Nomination clause la nominee name will be written. Which name? Nominee. Who is a nominee? Who will come and take the position of the member in case of death or incapacity? Everyone repeat. Of whom? Of the original member who incorporated the company upon his death or upon his incapacity. Another person will come and sit in his place to continue as a member. That particular person we call as a nominee. For him a clause will be drafted. What clause? Nomination clause. That's what we are going to discuss now. Everyone understood? Just one line answer. Start. The memorandum of a company shall state, in case of one person company, the name of the person who, in the event of death of the subscriber, shall become the member of the company. So tell me, this clause is also called as what clause? Okay, write down there, nomination clause. This is called as a nomination clause. So that clause of memorandum we call as a nomination clause. Clear everyone? Okay. Now we have completed section number 4 over. Main parts of section number 4 completed. So section 4 we started beginning today, we completed it. Section 13 also like that. 1 or 2 points only remaining main concepts for the exams we have completed. Section number 13, please come up. Capital clause alteration we didn't see. 13. Please read subsection number 6. Save as provided in section 64. A company shall, in relation to any alteration of its memorandum, file with the registrar a special resolution passed by the company under subsection 1. Approval of central government under subsection 2 if the alteration involves any change in the name. That's all. Sir, this is not a great point. Whenever you pass which resolution? Special resolution. File the special resolution with whom? ROC. If you remember, we have kept that as a point for all the sections. File with ROC within 30 days. File with ROC within 30 days. Did you remember or not? So you need not separately read this point. We have already done this. But why I am asking you to read this point is, save as provided in section number 64. Section 64 will be talking about alteration of capital clause. There are 2 sections talking about alteration of capital clause, 61 and 64. This is 64. Why, sir? We will come to share capital chapter. At that time I will explain you the why they are said like this. Not now. You can't even understand why it is coming like this now. When we come there to that particular chapter, I will explain you. Sorry, nothing great in this. Subsection 6 over. I just want you to tell, had we completed all the points in section number 13, subsection 1 over? 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, read 11. Over. Any, sorry, please. Let's complete everything in today's session, please. Let's start. Any alteration of memorandum in case of a company limited by guarantee and not having share capital, purporting to give any person a right to participate in divisible profits of the company otherwise than as a member, shall be void. First read this. Please read the content. Please don't waste time. Hello everyone, please read the point clearly. Subsection number 11 of section number 13. Completed that? See here. Any alteration in the memorandum. In case of which company? Company limited by guarantee. That means having share capital or not having share capital? Share capital. Purporting to give any person a right to participate in the divisible profits means it a right to participate in the dividends of the company otherwise than as a member shall be void. This is the point. Sorry. In chapter called as a share capital, we will get a reference to this with a very big section. As of now, I will give a summary. Remaining content we will see in share capital chapter. Point is very clear. Listen carefully first. First point number 1, there is an alteration. There is a alteration. Alteration to what? Memorandum. Company considered is a company limited by a guarantee and not having a share capital. Purporting to give any person a right to participate in the dividends of the company otherwise than as a member shall be valid or void. Means how to read this? If you observe, please listen. Any alteration of memorandum shall be void. In case of which company? Company limited by a guarantee. When which gives any person a right to participate in the divisible profits of the company other than as a member. I will give you an example. See here. Company objects clause they are making change. So objects clause change happened means change is in the alteration of a memorandum. Objects clause they are making a change, saying that this guarantee company can issue ESOPs. Can issue what? ESOP. ESOP means what? Employee stock options. Or they are telling that employees of the company will be given a share in the profit of a particular company. Guarantee company I am talking about. Simply to understand the logic, guarantee companies, whatever, whenever they are incorporated, their money will be coming only through whom? Members of that particular company. Not in the form of shareholders, but in the form of guarantee. Remaining all the people will give in the form of donations. Now listen carefully to the point. Just we are coming up to that. Whenever I refer to a guarantee company, just now I given a hint previously, 15 minutes back. Those companies will run not because of shares. Those companies will, those companies will run only in the form of donations, subscriptions, membership fee. Clear or not, everyone? Yes, therefore, donations are given. What will given? Donations are given. Subscriptions are given. There are two types of persons in case of a guarantee company. Number 1, those who are paying the donations and becoming a member of a company. If you become member of a guarantee company, you have to bear the guarantee for sure. You have to take the example. I will tell you. There is a club called as a Rotary Club. I became a member in Rotary Club. Tell me, I am a member, just I am a participant. Answer. That's all. I have nothing, no concern about that Rotary Club now. If I don't pay the fees, they don't consider me as a person. If I pay the fees, I will be enrolled as a person. As simple as that. Our relation is a commercial relation. Clear? Now let's see. There are two types of person in case of a Rotary Club. Number 1, type 1, like me. 95% will be like me. Another 5% will be there. Who are they? They are not only the donors, they are also the donor come members of that particular company. Listening, everyone? Yes, sir. During a particular year, Rotary Club has got a huge profits, like during COVID time. Previously, they used to conduct physically all the seminars, etc. During the COVID time, everything, money has been saved a lot. Just a small internet, good connection is required, that's all. They conducted all the sessions only through Zoom. Cost is reduced by 90% almost. Clear? Here, physically, if you have to conduct a staff required, persons has to come, electricity cost, all these things will be there. Zoom means just like that we can give. Cost will be reduced to 90% reduction of cost. Because of that, huge profits have come to Rotary Club. Example sake, let us take. Now, it want to distribute its money, the excess profit, whatever it has got, not only to the guarantee members of that particular company, but it also want to distribute to the other donations and other members of the company. Listening everyone? That's what he is talking about. Guarantee companies, though it got a huge amount of profit, it can give its dividends only to whom? Members who gave guarantee, not to the other persons of that particular company. Did you understand or not? Yes, even originally that is not there. Now you are altering in the objects clause and you are writing that provision also will become void. Did you understand the concept? Yes, but I don't have faith on you. I will repeat. Tell me, I will ask a question at least. Answer this. Okay? Tell me, which company we are talking? How many kinds of persons will be there? Number one, members. Seriously, they become members. They will also undertake what? Second one is only a donor. They are not members. They are all what? Donors. Okay, if you want, you donate. If you don't want, you don't donate. Answer over. Khatam. If I give money to a temple, donation. If I don't give a donation, what will happen? Is there anything happening to temple? No. If I pay, something happens to me. No, nothing will happen. It is only out of a person's intention they will give money. Clear or not everyone? But a temple trust members will be there. They are having direct contact with the temple. They will get benefits of the temple. But we don't get all those. Sorry, example I will tell you now. Tell me, I will ask you a question. You should give an answer. Which company we are talking about? Company limited by shares or company limited by guarantee? Very good. Number two, it has got profits. Those are called as what profit? Divisible profit. Means which I can pay dividends. So then why is using the word divisible profits? Why not profit? Question will arise. Whenever profit comes, some amount I will pay, some amount I will transfer to reserves. Some amount I will transfer to fund. Some amount I will pay tax. Some amount will be used for appropriations. After paying everything, lastly some residue will be remaining. That we call as a divisible profit. Means not divided profit. What it is? Divisible. If you want, you can pay as a dividend. Clear everyone? Yes, that amount is paid. If you want, you can pay. If you want, you can pay that amount. All obligations have been cleared. Excess profit has come. That's called as what profit? Can you please explain? Divisible profit. Now tell me, which company has got divisible profit? Which company has got what? Profit, divisible profit. Means after deducting all the expenses, obligations, appropriations, charge, everything after deducting, transfer to general reserve, everything over. Even after that, what is pending? Divisible profit came. Now it want to distribute that amount not only to its guarantee members, but it also want to give to other members of that particular company. Cannot? I want to change objects clause. I want to insert this as an object and I will pay. That objects clause change also will become void. He is telling there. Now everyone understood the concept? Over section 13 completely. So this is the last subsection number 11. Very important, sir. Not yet tested in exam. If you want, you can test the question. 2 marks questions like they can come. If I were to give a chance in exam, I will ask that question. Sorry, okay. Sir, we have now completed. Entire clauses of memorandum has been completed. Totally. Nothing to ask in examination beyond this. I am the guarantee. No question can come in examination beyond what we discussed now. In the last 4 days or 5 days, what we discussed in clauses of memorandum, those only will come. Bring any question paper, any number of attempts, questions will come only from the ambit of what we discussed. Lesser than that only they will come. Clear? With this we have completed the concept of clauses. Next, I am not going to start anything, just I want to give the blueprint of what we are going to do. So now we completed basics. Basics after we came into the clauses of memorandum. Which one? Clauses of memorandum. And that is also completed. Just for sake of understanding, learning objectives, I will show you what we completed. What is the first one? Can you please read for me? How many are there? First one, promoter, registrar, memorandum, articles. Completed, not yet completed. You should only tell me now. Clauses of memorandum basics. Had we completed or not? Which is section? Section number 4. Just now we completed. Over. Next one. Formation of company. Section 3. 7 members public, 2 members private, 1 member OPC. Do you remember? We completed. Next, analysis on memorandum. First, just understanding how many clauses are there. Basics. Over. After that, we went into articles. We didn't complete. Analysis on name clause. Contents over. Reservation. Rectification. Restrictions and prohibitions. Restrictions and prohibitions. Alteration. Very good. Next, alteration analysis on situation clause. Tell me, content of situation clause completed. RO section number 12. Engraven, affixing, all those provisions section 12. Okay, shifting of RO completed. In shifting of RO, we didn't just read 1 point, we read 4 points. Number 1, place to place within city, city to city, ROC to ROC, state to state. Table I have given everything. Completed. Next, alteration, analysis on what clause? Objects clause. Situation clause over. Objects clause. Name clause also over. So, contents over. Alteration of objects clause also over. Analysis on all other clauses. Just now we completed all other clauses. Okay. Next. What is the next area that we have to tap? Analysis on articles. Alteration of articles. This will be taking around 1 hour time. Easy, but 1 hour time will be taken because one important section 18 will be interlinked to this. 18 section will be talking about conversion of companies from public to private, private to public. Along with that we have to read it. Okay, so that will take around 1 hour, 1 hour 15 minutes. Good time will be taken to understand. Once completed, then we come into the most important areas in this chapter, doctrines. Hope you might have heard this before in foundation. What is the first one? Doctrine of constructive notice. Second one, doctrine of indoor management. Doctrine of ultra wires. Not virus, ultra wires. Next, effect of MOA, effect of AOA. Very, very important section. These we will complete. Once after completion of this, then we go into the incorporation related sections. Read how many incorporation concepts are there? Incorporation of company, basics, incorporation of OPC, incorporation of section 8, declaration of commencement of business, effect of registration. Once these are completed, lastly, miscellaneous. So, next session, we will be completing articles first. Once after completion of the articles concept, then we will be starting with doctrines under Companies Act. That takes 1.5 session. That means that session la half, next session la 1 full session it will take to complete all the doctrines with how the exam questions will come. Once that is all completed, we go to the incorporation related sections. Easy incorporation related procedure involved, nothing great. After that we go to the miscellaneous. With that, this big chapter will get completed. As of now, you may ask a question, how much percentage of second chapter we completed? 40% we completed. 40% we completed. Okay. Once clauses of memorandum is completed, 40% completed. Next, doctrines, all these things are completed. 65 to 70% completed. When incorporation is completed, 95% completed. Last miscellaneous will cover the balance 5 and we will close this chapter. Sorry, main concepts, everyone, all the persons understood the clauses of memorandum. Next we will continue in the next session. Okay. Thank you.